Right, it's 4:30. We can begin. Good evening, friends. Uh, the pandemic is all around us, and the electronic platforms continue to give us opportunity to connect with all the members and use this technology as a platform to solve issues that concern everyone. This webinar is on a very different kind of topic. This is on SEBI Settlement Scheme for trading in derivative segment during the period 2014-15. With the reversal trades and other such matters. Now, this is a unique problem which is faced. Usually, the problems that BBF tries to answer are problems faced by the members of BBF, stockbrokers, and intermediaries. This is a rare occasion where almost 15,000 investors are affected by a particular SEBI action, and many investors have received notices from SEBI giving them an option to settle the matter, of particular terms and conditions. And most investors are rushing to the stockbrokers कि बॉस ये क्या है, हमें क्या करना है, कैसे करना है. And of course, it's a legal matter. Most of us would say, please take a legal counsel. But having said that, many of us also try to by very nature, stockbrokers have this habit to make the customer's problem their own problems and try to solve and guide as much as possible. So this particular webinar is more as a guidance webinar for the stockbrokers, where we have with us Advocate Shri Prakash Shah. Anybody who's involved with securities market and securities market litigation, hopefully very few of us would be aware of Prakash Bhai. Prakash Bhai is known to me since a long time. We almost students together in government law college. And
Yes.
then from that time I've known Prakash Bhai, and Prakash Bhai is again a person who has very deep understanding of working of capital markets and the securities law around the capital markets. And we have asked for his legal guidance on the legality and the situation as it stands. So Prakash Bhai will kind of give some insights into his understanding from legal point of view, how we stand, and also from every point of view that he can think of. And post his talk, we will have a Q&A session. Again, in BBF Q&A session, we have a verbal Q&A session. So you could just raise your electronic hand when asked for, and then we can take answers one by one. Over to you, Prakash Bhai.
Thank you, Uttam. It is really my proud privilege to be associated with BBF, which is a globally well recognized amongst Association of Intermediaries of Capital Market and also recognized by Indian regulators, stock and commodity exchanges, depositories as an apex body of the Indian securities firms. It is well deserved and renowned a firm as on that. Today, I am asked to give my presentation on SEBI Settlement Scheme 2020. The scheme is framed to bring an amicable end to the proceedings proposed to be initiated and also made applicable where proceedings were pending before Honorable Tribunal. Here, today, my endeavor is to present before the allied class of capital market about the complete facts, circumstances, and surroundings of the scheme in most lucid manner. The objective is that the recipients of the letters from SEBI themselves are in a position to take prudent decision based on individual facts and circumstances of its case, and the mindset also it prevails. It is therefore important to focus on the three parameters of the today's discussion, namely background of the SEBI action, details of the scheme, and current legal position. Since the same is ever changing, the legal position, as we have seen, is ever changing as and experienced by all of us. Now, coming to the subject matter, the proceedings relate to execution of reversal trades in stock option segment of BSE during April 2014 to September 2015. That is a period of 18 months. Those trades which are alleged to be, non-genuine trades, and the volume which is generated therein is called artificial volume. So there are two factors. One is non-genuine trades, and that combined with the artificial volume. Now the trade is non-genuine based on what? So there are parameters which I will specifically highlight. One is synchronized trades. Then second is reversed on the same day with the same party. Third is price differentials between the first and reversal trade is significant with no change in the underlying price of the script. Fourth is constantly repetitive nature of trades resulting either in profit or loss. And mainly such trades are carried out by the persons who are not regularly dealing in the stock market. Now these parameters fits into most of the notices if they are worried about the outcome. If they are excluding this part, that is synchronized trade, reversal trade, then the differential between the two price is not that large, or there is no consistency in profit throughout or loss throughout, it is mixing, then possibly they have a different case. Now, these trades, which I have said, which is synchronized, reversal, repetitive in nature, are considered to be fraudulent and unfair trade practices as carried out by the person. Now, here the word importance is practices. If a person has carried out a single trade, whether it can be said to be indulged into a practice or an isolation trade, because practice requires that a person is engaged in a continuous basis in the business. So I'm just trying to make out a case that the trigger is that it is a fraudulent and unfair trade practice. So a person who has carried out regularly such activities can be said to be in a practice. Otherwise, it is a coincidence. Now, based on that, what is triggered? Triggered is SEBI Prohibition of Fraudulent and Unfair Trade Practices Relating to Securities Market Regulation 2003. Now, under that provision, what is alleged? If the trades are fraudulent, then Section 15HA, which is proposed to be applied in those cases under the proceedings where the penalty of not less than 5 lakh and which may extend to 25 crore or 3 times of the profit made, whichever is higher, is prescribed. So now this is the background of an overview of the subject matter of the present discussion. Now coming to the first aspect of the matter, that is background of the SEBI action. As I have said, that summarized. Now initially what had happened is that SEBI had come out with an order on the 20th August 2015 against 59 entities. I will just share with you the outcome of that order. That order is finally culminated into an order of 5th April 2018, correct? Where the under the para 2, it is mentioned that SEBI had passed an interim order dated August 20th, 2015, restraining 59 persons or entities from buying and selling. Now, here the threshold was persons who have made profit or loss exceeding 5 crore was the threshold, which is made out under the table. The aforesaid 59 entities were shortlisted in the preliminary examination based on various parameters, including reversal of trades with the same counterparty either on the same day or the next day, buying and selling equal units of stock options of scrip, profit made or loss incurred by each entity by reversing the transaction in excess of rupees 5 crores. So today we are faced with around 14,720 entities, whereas at the first instance, the test measure was carried out against the 59 entities. Correct? Now, what had happened it ultimately? It is said that when the investigation was concluded, he says, I have considered the findings of the investigation report. I have also noted that pursuant to completion of investigation, 14,720 entities of all have been identified as having violated provisions of PFUTP regulation. I note that adjudication proceedings have been initiated against 567 entities. Now here it is a catch, saying that initially the proceedings were initiated against 59 entities with a threshold of 5 crores, which was made out in the order itself. Here, on the conclusion of investigation and when the order is passed, as on that date, 567 entities were already under adjudication proceedings. Now, the parameters of identifying 567 entities are in dark, which we are not aware. How, in what way 567 entities were selected out of 14,720? Whether this 567 had a larger volume, etc., is a presumption and the calculation that one has to make out. But 567 entities were under adjudication proceedings, as on date, we have large number of orders out of 567. That is around 436 orders have been already passed. Remaining, will deal with that. They are already applied for the settlement applications under the regulation, etc. Now, here it says that I am inclined, phase one, including 56 entities who were involved in execution. So, as on that date of the passing of the order, 567 entities were identified for the first level prosecution, that is adjudication proceedings. At the end, the whole-time member, learned whole-time member concludes that the adjudicating officer shall continue and conclude the proceedings in accordance with the SEBI Act 1992 and SEBI adjudication rules and pass appropriate orders on merit at the earliest, uninfluenced by this order, since the order is passed without examining the merits, in consonance with the regulatory objective that imposition of monetary penalty as per law in line with similarly placed entities would meet the end of justice. So here, reading the learned whole-time members' final order on this conclusion of the proceedings and post-investigation, the conclusion is absolutely drawn that the imposition of monetary penalty as per law in line with similarly placed entities would meet the end of the justice. So finally, one has to take a final view on the subject matter, that what will ultimately result into an imposition of monetary penalty against all the entities. That is what is concluded. And that is also as per the learned whole-time members order, which is also a benchmark judgments. Now, incidentally, I would like to mention that proceedings were also initiated against the brokers who had carried out the large number of trades on behalf of the clients. The order was passed on 12th August 2016, wherein, on the conclusion of the investigation proceedings, it was decided that the interim order which was passed against these brokers got revoked, and on the conclusion of investigation, if any action is required to be taken, will be considered. And we have seen the earlier order, which is a final order post investigation. Therein it is concluded that the entities who have carried out the trades will face the adjudication proceedings and will face the consequences, that is monetary penalty. Now, coming to the subject matter of 567 entities against whom the order in adjudication proceedings were initiated. Now, we, with the help of my staff, we have made the compilation of the orders in the manner that what is the amount of penalty which is imposed. Then, per penalty, how many orders have been passed. Then the range of contract, which is now 3 parameters, which has been made out in the settlement regulations. So we have summarized that the range of contract, range of trades, and range of volume, because there is no uniformity in imposition of the penalty by different adjudicating officer or by the same adjudicating officer. But for the references, because this is a benchmark, that what are the consequences. Finally, as I have read out from the learned whole-time members order, is that it is finally the ends of justice will meet with imposition of monetary penalty against all these entities. Now, what is the monetary penalty that is imposed in the settled cases is, let us say that in one case, no penalty was imposed because the company had gone into the liquidation, though there were 169 contracts, 451 trades, etc. In case of Rotomec, there is no penalty which is imposed on the ground that I note from above that it is mandatory and a precondition to obtain the leave of Honorable NCLT for commencing the instant proceedings against the noticee, which is under liquidation in terms of order dated 23rd March 2018, passed by Allahabad Bench of Honorable NCLT. I note that there is no material on record to suggest that leave of Honorable National Company Tribunal, Law Tribunal has been taken in the instant proceedings. So, in one case, because the company had gone under liquidation, no penalty was imposed. Otherwise, we come back to the main part of the analysis of the orders passed by the learned adjudicating officers in this matter. Correct. So we see that around this 277, we had been able to get the 3 data. Otherwise, to my knowledge, it is around 284 orders, correct, where penalty of 5 lakh rupees is imposed. The range of contract is from 1 to 53. The range of trades is 2 to 484, and the volume is 5.66 lakhs to 8 crore 71 lakhs. Now, this is an analysis, this is a benchmark which may help us to ascertain, in case if I am not settling the matter, what penalties that could be imposed by the adjudicating officer, has a benchmark of these orders which we equalize. However, as we have, it can be seen from this table that there is no broader uniformity in the, or the consistency on the three parameters. So there is variabilities. Rather to say, just show the full screen of the total orders. So in case of 561 contracts, that 84, this 530 contracts, 84 lakh, highest is 1 crore 15 lakh was imposed. So ranging from 0 to 1 crore 15 lakh penalty has been so far imposed based on this volume as we have considered. So this is the background as on date. What SEBI, the first subject matter is with regard to the background of the SEBI action and what is the stage today. Now we come to the second subject matter is details of the scheme. Now, just to simplify the process and procedures, SEBI has come out with a scheme 2020 with regard to this pending adjudication proceedings to be initiated against around 14,000 entities. By now, since the scheme has come in the last week of July, we are in October, so everybody must have gone through this scheme number of times. But the subject matter which I have discussed includes everything what it says and what it is made out, saying that out of 21,652 entities who have carried out the transactions during the relevant period, they have found that 14,720 entities have indulged into artificial volume and non-genuine trades. What can be the possible difference is that those persons who have carried out transactions, either they have not reversed the transaction with the same party, or they have executed trades on the expiry day, etc. There are certain possibilities, because finally in illiquid stock option it is case settled only. So 7,000 entities are excluded from the said allegations of indulgence into artificial volume and non-genuine trades. Since we have the data which is available in the public domain by way of getting an adjudication orders from the regulator, otherwise we do not have the total analysis of what are the this indulgence of these 7,000 entities against whom the action has been decided not to be initiated. Now, the parameter which has been considered by the board while settling this, framing the scheme is, the board has considered three objective parameters. That is, namely artificial volume, number of non-genuine trades, and number of contracts. So these three parameters are being considered for factoring the amount of settlement amount for each entities. And that is also, they must have made out a formula based. We are aware of the outcome of individuals. It is very difficult to so far find out the way we have said that we have been able to make the analysis of the adjudication order, because the data is mentioned about the number of trades, number of contracts, as well as the volume. Whereas here, because everyone has to log into through their pen numbers, so somebody has to work out to finally find out the rationality about the same. Now, what is the scheme details? The scheme details are that under the scheme, the entities who have executed reversal trades during this period are entitled to settle one-time settlement, and this one-time settlement period shall commence from 1st August to 31st October 2020. Now we are already on 13th October, so 2 weeks are still left out for the persons to take a decision. Now, what is ultimately held, that suppose ultimately if a person does not settle the matter, then what is made out is also there mentioned. It is clarified that after the expiry of the scheme, entities who do not avail the one-time settlement opportunity shall be liable for action as per Section 15I of the SEBI Act. Now, Section 15I of the SEBI Act, let us go through that Section 15I of the SEBI Act. It says power to adjudicate. So, for the purpose of adjudication under Section 15A, etc., that includes, which includes 15HA, correct? So, our adjudicating officer will be appointed, and after being heard, imposing any penalty. So, finally, the crux of the issue, even in the as we have seen in the learned old-time member order also, it is categorically mentioned that ends of justice will meet with imposition of monetary penalty. Here also the settlement schemes makes out a case saying that ultimately, if a person is not opting for the settlement scheme, it will result into imposition of monetary penalty, because many persons are otherwise scared whether our demat account shall get debarred or we will be restrained from exercising in the stock market, etc. That power is not with the adjudicating officer, it is with the whole-time member. That is why just I am making a clarification. I am not going into the nitty-gritty too much about the settlement scheme and the legalities, because as on date, we have understood that few of the aggrieved persons are approaching the honorable courts and etc. about the jurisdiction or implementation of the settlement schemes. We have to still wait for the outcome. But just to clarify the matter, under the regulation, settlement regulation, under regulation 26, SEBI is empowered to make out a scheme, settlement schemes, after following the due process of law, which is acceptedly, they have carried out the due process of law before coming out with the settlement schemes. There is no, there is no question of doubting the nitty-gritty of the procedures or any lapse on the part of SEBI board before they come out with the settlement schemes. Now, what is an effect of settlement order on third party right or other proceedings? That is very material, because it is an impact of other simultaneously. Many people apprehend and feel that what about the other proceedings that may be initiated if we settle the cases under the settlement order. So under 27(1), it is made out that a settlement order under this regulation shall not be admissible as evidence in any other proceedings relating to an alleged default not covered under the settlement order, nor affect the right of third parties arising out of the alleged default. So this settlement order, when passed, cannot be relied upon or it cannot be made as an admissible evidence under any other proceedings. So there is no otherwise need for any other clarity, because the regulation itself provides for immunity from other proceedings. Now, just to further enlighten the listeners about this, SEBI has also come out with a FAQ, which clarifies certain doubts and the assistance that can be made available to the persons who want to avail of the settlement scheme. So this FAQ makes out, under the question 8, what action will be taken if the one-time settlement scheme is not availed? The entities who do not avail the one-time opportunity for settlement within the prescribed period shall be liable for enforcement action. In respect of the cases where adjudication proceedings are initiated, action would be taken in terms of Section 15I of the SEBI Act. Now, what will the settlement order be passed? When will the settlement order be passed under the scheme? Subsequent to the closure of the scheme, a composite settlement order would be passed by the competent authority after reconciliation of records. Then, should I wait till the last date for filing the settlement application under the scheme? It is advisable to file a settlement application under the scheme as soon as possible in order to avoid last rush. Sufficient time of 3 months have been provided under the scheme. So now this is what has been made out in the FAQ. Along with FAQ, annexure 1. Self-explicit. So a person who wants to avail of the scheme, if he can follow the FAQ, he will be in a position to complete the process of settlement without any other assistance as otherwise, because they have made out the FAQ in a composite manner, and also as we have seen that the email ID is also created for the settlement proceedings to be concluded. So, and we have understood that whenever any email communication is made on that email ID, the reply is received. Now the question remains is, what is the parameter for making a decision of either settlement or adjudication? Finally, there are two things one has to face. He settles it or he faces an adjudication proceedings. Now, just for a comparison, I just have a two, parameters for the settlement. Now, here in case of Global Earth, where I had entered the case, the settlement amount is 21,17,500, whereas the adjudicating officer had imposed a penalty of 6 lakhs rupees, which is a benchmark order passed by the Honorable Tribunal in these cases, which I will come to the legal position. Now, the second order, which is there of Aslar, here the settlement amount which is proposed is 44,42,500, whereas the adjudicating officer had imposed a monetary penalty of 71 lakh rupees. Second page. So, second page.
71 lakhs.
So these are the two comparable figures which we want to mention, saying that it is not necessary that the settlement amount is uniformly larger than the adjudication. There is a variance between the two. So to the extent I have clarified about the details of the scheme, and then we will deal with the same. Now, just to mention that even in case of Ajay Garg, where the volume was single share, single script, two script, there also the penalty of 5 lakh rupees is imposed. Correct, there is a single trade.
5 lakhs imposed. Yes.
Now, coming to the third aspect of current legal position with regard to these transactions. Now, in case, let us say the people are apprehensive, saying that if I do not settle, whether there is a case for me to argue before the learned adjudicating officer or not. Now, we are just, as a matter of fact, discussing the subject matter. It is not an indicative aspect to say that there is no reason to fear at all. However, the subject matter, how we can differentiate between the two settled orders, that is of Rakhi trading as well as the tribunal who has taken a decision upholding the adjudication orders. Now we come to that. Now in those cases, what had happened is that it is an allegation of synchronized trade. Now synchronized trade impliedly means that the execution of placing of an order, the time, quantity and rate matches in equal measure. So those cases, as we have seen, that SEBI initially had taken, selected 59, then selected 567. Now remaining, one has to identify whether these trades are synchronized or not is first factor to be considered. In case the trades are not synchronized is that the counterparty client and yourself, whether the time at which the order was placed, whether the quantity and whether the rate, which was, it is equal, identical. That is one factor which one has to look into it. If it is different, there is a difference, then there is a ground to argue before and put a defense. The second thing is about the allegation of artificial volume. Now here there are two parameters. Now in every so-called notice, they have properly made out that what is the percentage of non-genuine trades of entity in the contract to total trades. So now if the percentage of non-genuine trades are larger, then necessarily there is a case to say that you have in proportionality, you have indulged into a large number of trades, which is a practice, so-called fraudulent practice. Second thing is artificial volume. Now the volume of a person which he has dealt with in the contract, if that percentage to the total market volume is negligible, then there is always a defense available to the person saying that there cannot be an allegation of artificial volume because my volume is insignificant to the market volume. So no allegation of artificial volume is sustainable. So these two parameters are the catch for the person to prepare his own defense. Now, second aspect of the legal position as on date is that NSE has come out with the circular dated 13th December 2018, where specifically the brokers are cautioned that in case if they indulge into, or their clients themselves or on behalf of their clients, if they indulge into such transactions which results into, with an objective of transferring profit or losses between the concerned entities or creation of artificial volume, then penalty up to 100% of the profit or loss made out is can be imposed. That is the first circular, that is dated 13th December 2018. The third para which reads out, the exchange sale, correct? The last line says the penalty of 100% of the traded volume, profit made, loss incurred as a result. Now then thereafter, there is another circular of 7th February 2019 in continuation, and the third circular is 4th of February 2020, where it is made out that a minimum penalty of 15% of the profit will be imposed. So it is to be noted that exchange shall levy a penalty of a minimum of 15% up to a maximum of 100% of profit earned, loss incurred on the trading members for both profit and loss making abnormal non-genuine transactions. So now the burden is on the broker to ensure that their clients do not indulge into the so-called such alleged transactions which results into non-genuine trades or artificial volume, mainly with an intent to shift the profit or loss earned. Now, this indirectly or otherwise expressly implies that SEBI has now shifted the onus and the burden on the exchange to filter out such transactions and punish the brokers, not the clients, because exchange cannot punish the individual clients because they are not individual investors are not under their jurisdiction. Therefore, now it is for the brokers to ensure that such activities are not being carried out. Now, coming to the settled cases with regard to the settlement, correct? As I've said, that there is a first is benchmark judgment of Global Earth settled on 14th September, correct? Where the four notices or the orders were settled by way of dismissal of the appeal and upholding the adjudication officer's order, making the parameter case saying that in the case of Global Earth, large number of transactions resulting into the losses were entered into, and there was no justification that why a person repeatedly incurs losses and also continues the trading of such a nature which results into losses. So there was no rationality. So this was such a case. So the facts which have been made out has an applicability to Global Earth because it was a loss the transactions throughout in totality. Second is, at one stroke, the Honorable Tribunal has passed order against 66 appellants on 17 September. Now, possibly there can be a reason to say that now mostly no appeal is pending on the subject matter, or maybe one or two which may have been pending. Otherwise, the order passed by learned adjudicating officers are upheld, and even the proportionality aspect has been dealt with, saying that the amount of penalty as imposed by the adjudicating officer does not require any interference by the court, and that has been what is settled. So now one has to make out a case to ensure that individual case does not fall into the parameters as mentioned in these orders or in the matter in the other adjudicating officers order passed on the subject matter. That means, as I've said, that synchronized trades, reversal with the same party on the same day, consistently resulting into profit loss, multiplicity of transactions, repetitive nature, then the person is only indulged into such activities. Otherwise, his business is different. Only these transactions have been entered into by them. So these are the factors one has to look into. So one cannot just generalize the subject matter saying that yes, you should go for settlement or you should not go for settlement. The SEBI will have cannot paint every person with the same brush necessarily. If the facts are different, there will be a ground for the regulator to look into the subject matter and differentiate the cases against what is settled. Now, in distinctly, what was made out even in global earth was that the distinction was drawn between the Rakhi trading judgment, which was largely relied upon while passing the order. In case of Rakhi trading, the when the common party was there, counterparty, the proceedings were initiated. Whereas in the Rakhi trading itself, when the single trades were executed with a different party, they not with the commodity, then they were excluded. That is also being held in the tribunal's order. So that is why I was just relying on the tribunal order. And the order which has been Supreme Court's order is making out a proper case with a detailed chart that in what manner in large volume of transaction and large volume of transactions the trades were executed. So it is not a single trade or otherwise. If we look into the trade order log file which has been reproduced in the order, we will find that it is with the same party, and the one party is incurring loss, the counterparty is Kasan Holding, and the other party is Rakhi Trading, and they are all synchronized trades and etc. So if one is in a position to differentiate the facts, necessarily someone has a ground to suggest saying that his trades cannot be considered as fraudulent. The facts which we are relying upon is a settled cases about global earth where repeatedly the transactions of losses were executed one after the other, even if it is resulting into losses. That was the ground where rationality was not applied. Whereas in that case also, it was largely argued and differentiated that Rakhi trading is not applicable because the counterparty to the transactions are different and not the same. Now coming to the other grounds which is available to the notices is about the delay. That in 2014 the transactions were executed, or 2015. Now we are already in 2020 and SOPOS is not issued. So even the Supreme Court in case of Bhavesh Pabari saying that if securities market and securities markets and exchanges, Securities Board of India 15A and B, reasonable time within which notice can be issued, what it is. So it is made out that the notice is required under para 35. It has been elaborately mentioned that even if there is no time period specified, the notice is required to be issued within a reasonable period of time by the regulator. As on date, we are aware that around 6 years have already passed from the date of impugned transactions. Thereafter, repeatedly, the Honorable Tribunal has considered the subject matter of delay in the recent order that is of 8th September in the matter of Bharat J. Patel and others. It was merely on the ground that there is a inordinate delay in initiation of proceedings. The order was quashed and set aside. If we desire, we will. It is covered under page 8 and 9, having heard the learned counsel. So it is not on merit. The appeal was allowed not on merit, but it is on the ground that the facts on record would show that the disputed trades were carried out by the appellant in the year 2012. The SOPOS notice was issued to them on July 10, 2019. So there is a gap of 7 years. So on that ground itself, the Honorable Tribunal was kind enough to quash the AO order and allow the appeal. Now, another subject matter is about the settlement is when there are ITAT judgments in case of DCIT and Anil Ambani, where it was held that the this is it that this amount of settlement amount paid by the person is allowable expenditure. And the another order is of Prabhudas Liladhar. In both the cases, ITAT has upheld the settlement amount paid as an allowable expenditure and not covered under the explanation to section 37(1) of the Income Tax Act. So they have considered these two. There are judgments to say that the amount paid under settlement will be considered as an allowed business expenditure. In the case of the fear of income tax, saying that if these transactions are passing through the adjudication or otherwise, whether there will be a case to trigger the income tax proceedings under that. So section 68, there are a large number of orders passed under the LTCG also, where it is held that there are three parameters which is to be considered under section 68. Importantly, in this case, necessarily the transactions are still accepted to be genuine in the books of exchanges. Even the settlement of the trades have been carried out by the clearing corporation and there is no dispute. So necessarily every parameter for the genuinity of the transaction, that the issuance of the contract is valid, the process pay in and pay out has also been carried out, it is also assumed existence, there is a payment by banking channel, etc., with the counterparty, etc. So in that regard, there is a good scope to say to defend before the tax revenue authority, saying that it cannot be considered to be otherwise than the genuine transactions. Broadly, I have tried to cover the 3 points as given to me. Now I open the floor for the question and answer or any other thing that has been left out by me. Thank you, Uttamji. Mic is yours now.
Thank you, Prakash bhai. So we can move to Q&A session. And okay, अब basically सबके सवाल एक ही है, मुझे क्या करना चाहिए? What should I do? And I asked this to Prakash bhai also few days back. क्या करना चाहिए? Incidentally, मेरे ऊपर कोई order नहीं है, these are me and my relatives, but still. So, Prakash bhai, it's a very case to case thing. You cannot form a general statement कि ये करना चाहिए नहीं करना चाहिए. Every case is unique, but the parameters in which you determine क्या करना चाहिए has just been largely touched upon in this webinar. So we can take Q&A. The Q&A in BBF style is you can raise your electronic hand and we'll give you a chance to speak, and then everybody can hear you, so you can then ask your questions one by one, and then let's see how it goes. Not every question can be answered. If your question is controversial or cannot be answered in public forum, then please you'll have to excuse us for that. Yeah. Can the admin please set the speaking permission on for Manish ji, boliye.
Prakash.
Yes.
Sir, I would like to know that how do you determine whether the trade that has been carried out, it has been determined through the system, SEBI system.
Correct.
Don't you think they should have at that stage only stopped us from doing the transaction, or the broker should have been stopped from doing the transaction if they are regulating the entire system?
मनीष जी, ये तो बस जब कोई ट्रैफिक सिग्नल तोड़ रहा था उस वक्त रोक देना चाहिए था, तुमने तोड़ने क्यों दिया? सर ये लॉजिक तो नहीं चलेगा ना.
But the system is of
सर ये सब थियोरेटिकल बात है, अपने इसको क्रॉस कर चुके हैं मनीष जी. ये सब क्या बियर के ऊपर बात करके बियर पे बैठ के ये सब बातें करना चाहिए? वी आर टू स्टेज टोटली अ लीगल सिचुएशन राइट नाउ. लीगल पॉइंट्स पे रहे तो बेटर है, कॉमन सेंस में ना जाएं प्लीज.
अच्छा सर, how do you determine how can you find out whether your transaction is the details of the other side, whether that is matching the other side or not?
वैसे when the show cause is issued, they will provide you the details of the trade order log file necessarily. Under the adjudication rules, the learned adjudicating officer is duty bound to provide all the facts and material so that you can prepare your complete defense.
But then, sir, don't you think it should have been provided at this stage, or can we ask SEBI to give us at this stage so that we can be more clear about things or are supposed to be done? You know?
Possibly, you can send an email to the from where you have received the letter or communication and ask them. Incidentally, in few cases, the persons have asked for it and they have provided. You can try right now also.
Sir, and see, I have been dealing regularly in the stock market. So, do you think it is a case for setting that it is not a, and I have been formed for generating profit? So, don't you think it is a genuine case from my side that I have been regularly dealing in the stock market?
The point is, as I have conveyed to you, that here my job is to give a broader picture that whether you can differentiate your case from a settled case of Rakhi trading as decided by Honorable Supreme Court and as a landmark judgment of global earth. So please put your efforts to go through those facts of the case and try to differentiate your, the subject matter, your case. If you are able to differentiate your facts from these two settled orders, I say that then you can take a risk of, risk, or you can continue with the proceedings. Is a general answer.
Okay, sir. Thank you, sir.
Okay, Chirayu ji.
Yeah. Good evening, sir.
बोलिए सर.
मैं I just want to understand that जो notices हमारे पास आए हैं, क्या हमें my point is कि मैं उसके settlement scheme में नहीं जाना चाहता. मतलब after listening to Prakash bhai, I am of the opinion. Now, should I respond to their notices that we have received, or I should wait for the anything else that should happen from their side?
Honestly, when a respectable organization like SEBI issues a communication, it is expected that you respond to them as a courtesy, as a conduct. Mandatorily, there is no requirement. I repeat, statutorily or mandatorily, there is no requirement to respond. However, as a good conduct or as a response, as a person, you may write whatever ideally you think better, so that the proper communication is complete. Whatever thing that you feel appropriate to convey.
Right,
but
sir.
yes, I suggest that reply has to be there so that your conduct is shown to be proper. In case of any change of proceedings and etc., it will be considered that you have responded to it.
Okay.
Because finally, I'm just asking you, you are going to accept the further correspondence. I'm just saying so. The person who doesn't want to exceptionally, I'm not giving any hint to that person, but I'm just trying to say, yes, response is desired.
Right. Thank you, sir. Thank you so much. And just another thing that इसमें while जो ये transactions की data हमको दी गई है, उसमें एक ही अगर trade हुआ है, just one trade has happened. I mean, just one transaction has happened on a particular date. एक ही दिन में अगर एक transaction sale purchase कुछ हो गई है, so that will be considered as one unit, or how it is calculated like that?
So it is considered as one contract. See, there are three things which I would like to again explain for the benefit, of everybody's benefit. One is contract. Contract is like a script. The word contract is used in F&O segment. Whenever you deal in the derivatives, it is not the script, but it is a contract. That is one. So you have to see how many contracts you have dealt in. Another thing is trades. Now you have to see how many orders were placed, because trades is an outcome of the order. For one order, there can be 100 trades, or there can be one trade also. So you cannot be held responsible for 100 trades, because originally you have only placed one order. That is a factor. Then the third thing is volume in units, that it is not the amount. Normally in the script, when we say word volume, is always an amount in rupees, in currency, whereas here the volume is units. So you have to see that these are the three unique features of these stock options. I repeat, one is contract, another is trade, and third one is volume. contract is in the nature of, you can compare with the script, just as a, for the sake of simplicity. I'm not saying equally. They are not identical. Trade is, you have to relate back to the order and not the trade, because what he has punched in is the order. Volume is, you have to see how much is the volume. Now, what is alleged against you is non-genuine trades, correct? Now,
Right.
non-genuine trades is a reversal trade. That is one. The
Right.
artificial volume, now you have to compare your volume with the market volume of that contract at a large. So if your proportionality, the percentage of volume is too high, then it can be said that if it was an artificial volume shown to the market participants, and that is why it is fraudulent. So if the percentage of volume executed by you is not significant, then the charge of creation of artificial volume may not possibly sustain.
Right.
I hope
Sir,
I am
just
able to explain to you. If any
no,
further
no,
explanation for
I got it,
everybody's
sir.
benefit, I am ready to further elaborate.
No, no, sir. Just one more thing. Last thing to ask me is, in case we want these details, how can we get these details? Like I received it for 2 files, but the Excel sheet of the trades has been received only in one. So how can we have this data from the SEBI or something?
Correct. So you please send an email
Uh-huh.
to
Sorry.
the email ID from where you are receiving the communication. You can also
Okay.
be free to speak to the officials of the regulator. They are also available. They are kind enough to assist and resolve the query. But preferably, it is always through email communication. One should interact.
Okay.
And
The
once if
same.
it is not received, you may send reminders. But I am hopeful that they will provide you the legitimate details that can be shared with you. And these
Okay.
details can be shared with you. I understand.
Yeah, but sir, there is no email ID. Man, just email.
It
Ek
is
email
there.
ID.
You received the settlement regulations. If you want, I will just give you the.
Yeah, please,
It
please,
might.
sir. If
What
you
is an
can just
email
give
ID?
us the email. Yeah.
We will provide you with the. I will just give you in the 2-3 minutes.
Yeah, yeah.
It is
No problem, sir.
from
No
where
problem.
we are receiving the emails.
Right.
Right. Right, sir. Thank
Just
you
a
so much.
minute.
Thank
Just
you.
convey. Loudly say. Speak.
uh, SEBI Settlement 2020 at sebi.gov.in.
SEBI Settlement 2020 @sebi.gov.in. Thank you.
Even the
Okay.
officials of the settlement department, that is for regulatory action, they are also helpful to assist, but they cannot render services to the all the investors. So selectively one can talk to them.
All right. Anish ji.
Hello.
Anish ji.
Hi, am I audible?
Now I'm asking Mr. Anish ji if you can speak, please.
Yes, sir.
हाँ बोलिए.
Sir, we got an letter for an small amount of involved trade, only for only a one trade. So, can it's beneficial to pay or any chances to reduce amount of rupees 5 lakh?
सर आप ध्यान से सुन रहे नहीं थे इतनी देर से जो प्रेजेंटेशन हुआ. अनिश जी केस टू केस करना मुश्किल है बट प्लीज डू हैव अ लुक एट दिस वेबिनार अगेन. Prakash ji has given a overall look at the way SEBI has passed the orders, look at the way penalty jo laga hai, look at the criteria that has been that SEBI is following, that has been analyzed by the team. That will give you ideas. ऐसे कहना बहुत बड़ा मुश्किल है पब्लिक प्लेटफॉर्म पे कि क्या करना चाहिए क्या नहीं.
Okay, and another question is that is if we pay or we adopt the settlement scheme, if any implication of income tax comes or not?
You want me to answer?
Yes, Prakash ji, आपको ही बताना पड़ेगा.
See, the point is, finally, when you are settling the matter through consent mechanism, correct? It is specifically mentioned that the consent order may or may not include a determination that a violation has occurred. So normally people go for settlement just to bring peace of mind or for as a matter of settlement. It is not an admission or denial of the offense. That is first thing. So no other authority can take cognizance saying that you have indulged into a fraudulent trade because it is not settled even by the regulator in that regard. The other point is, even if, let us say, the adjudication order is passed, in that case also, as I have mentioned, that there are large number of cases which were initiated pursuant to the long-term capital gain matters. And Section 68 of the Income Tax Act, when it was triggered, people have been able to defend themselves before the ITAT as well as before the court, saying that finally that contract is a valid contract. Even today also, the exchange upholds, even if you check with the exchange, whether this contract still exists in your system, answer has to come yes. Whether the transactions have been carried out on the exchange platform, answer has to be yes. Whether exchanges consider that as non-genuine trade, answer is no. Exchanges always consider that to be a genuine trade. Exchanges also, whether all the all the transactions, that is so-called banking transactions, have been effected through the clearing and settlement mechanism of the exchange, answer is yes. So these are the factors one has to put forth and then argue, because finally one has to face the proceedings. So these are my general answers as a defense. And there also the criteria of long period of time, because even there are high court judgments saying that once the scrutiny assessment or any assessment is completed by of any nature other than 143(1), in that case, to reopen the cases of the previous year are not permissible. There is a recent High Court judgment also in the very recent case. So, I mean, these are the grounds which I am just mentioning to you, not promoting, saying that no action will be taken. So, one has to face the consequences and put forth all this, what is available to as a defense.
Thank you.
Vishal Jain ji.
Well, I forgot to lower my hand. My question was actually answered by you
Oh,
before.
perfect, perfect. Harsh ji.
Yeah, my question, Prakash ji, is that you were saying ki, we can check what penalty educating officer has given to us and what money is given by SEBI in settlement scheme. So we are able to know the money given by SEBI settlement scheme, but the penalty mentioned by educating officer, how can we check that?
Now, for that purpose, as I have shown and shared the chart, that today we have an analysis of around 436 order passed by learned adjudicating officer, correct? And out of those, there are total, let me repeat, that 567 adjudication proceedings had been initiated. Out of that, I am saying around 436 adjudication orders have been passed. Out of that, in case of 280 adjudication orders, the penalty of rupees 5 lakh is imposed. And in other cases, the penalty in the range of 5.10, etc., up to 1 crore 15 lakh has been imposed on a case-to-case basis. So I hope that rationality should prevail, because finally the penalty cannot be an arbitrary figure by whims and fancy of the in that regard. Hopefully, if you can compare your volume and other things and the large number of other order passed by the learned adjudicating officer, you can give an estimate, or you can have rely on that at the time of defending the case, or otherwise at an appellate authorities. Finally, one has to defend the case as a genuine trade. Ultimately, then there, if it results into a penalty, then the factor of arbitrariness may also be considered.
What I was trying to say, I've got no letter from educating officer. That is why I'm not able to know the amount. So how
अरे
can
हर्ष जी आपका एजुडिकेशन अभी तक हुआ ही नहीं है. एजुडिकेशन एक अलग चीज है, सेटलमेंट एक अलग चीज है. 14,000 में से खाली 500 आदमी का एजुडिकेशन हुआ है अप्रोक्सीमेटली.
तो अभी उन दोनों का कंपैरिजन अगर
नहीं, आपका कंपैरिजन पॉसिबल नहीं है. अभी तक आपको खाली थप्पड़ पड़ी, गोली मारा नहीं है, तो दोनों को आप कंपेयर नहीं कर सकते.
ओके. एंड
एजुडिकेशन जब होगा तब होगा. अब उन्होंने एक एग्जांपल दिया, एक बंदे का सेटलमेंट का फिगर 100 आ रहा था, पेनल्टी लगी 70. एक का एजुडिकेशन फिगर 100 आ रहा था तो पेनल्टी लगी 200. इट डिपेंड्स टोटली ऑन अ केस टू केस बेसिस.
मेरा हुआ नहीं सर।
हाँ वो हुआ ही नहीं, 13,500 लोग का हुआ नहीं सर।
और एक क्वेश्चन मेरा एक और ये है, वो ये है कि ये जो मेरा सेबी सेटलमेंट स्कीम है, इन दिस आई एम द क्लाइंट, आई एम नॉट द ब्रोकर।
हाँ तो
व्हाट इज द डिफरेंस इफ इन केस अगर ये चिट्ठी क्लाइंट को जाता है या चिट्ठी ब्रोकर को जाता है, व्हाट इज द डिफरेंस इन इम्पैक्ट?
सर क्लाइंट सारी चिट्ठी 14,000 लोग सारे क्लाइंट है सर, इस देश में 14,000 ब्रोकर नहीं है।
ओके
आप शायद आप लेट ज्वाइन किए क्या वेबिनार?
नहीं, मैं ज्वाइन पहले ही किया, बट टी टाइम
तो आप शायद मिस कर गए सर। एक बार आप वापस YouTube में अपना लाइव में यू कैन री सी इट, एक बार वापस फ्लो देखिए, कहीं सर आपका फ्लो टूट गया आई थिंक।
ओके ओके
ओके
थैंक यू सर, थैंक यू।
सन फिनलीज, नो? जयदीप हरिदास जी, नो? बंदिश हिमानी जी?
Sir, already answered the query.
Oh, perfect. हाँ हाँ। आलोक जी खेतान? No. आनंद जी झुंझुनवाला? सब एक्चुअली हैंड रेस करके भूल गए क्या आप?
Hello.
या बोलिए आनंद जी।
Yeah, sorry. Good evening, sir.
हाँ
A couple of questions.
हाँ
First is that to avail of this settlement scheme, one of the conditions is that any proceedings against me should be pending. So, the reason that I have not yet received any show cause notice, other than the communication in the month of August from SEBI, will it be deemed that proceedings against me are pending? I mean, as on date, I am, till that letter arrived from SEBI in the month of August, I was not even aware that something done by me in 2015, I mean, any action has been initiated against SEBI. So whether technically any proceedings against me will be deemed to be pending? That is the first question, sir.
May I answer?
Yeah, sure, sir.
Okay. As it is mentioned in the settlement scheme itself, and they have categorically mentioned that prima facie it is found that you have indulged into certain trades. Now, per se, till issuance of the so cause notice, no proceedings are initiated against anybody. It is only by way of issuance of the so cause notice, it is conveyed, it is intimated that proceedings are now started against the person. So this letter or a communication, in my view, does not amount to or tantamount to initiation of proceedings. It is pre-initiation of proceedings. They are opting and they are offering you whether to want to settle it or not. So in my view, it is pre-proceedings. It is before initiation of proceedings. This is the letter. So as on date, if this is the only letter which you have received, you can still say that there are no proceedings initiated against you.
So in that case, even if I am inclined to go for the settlement scheme, but this technicality is not allowing me to avail of this scheme.
No, what is a technicality? I don't understand. What is a technical subject matter which is hampering you in getting the...
प्रकाश भाई, if I understood you correctly, आनंद जी बोले जब मेरे खिलाफ कोई प्रोसीडिंग्स नहीं चल रही तो मैं सेटल कैसे करूं?
एकदम सही बात आपने कही।
अच्छा, तो ये सेबी सेटलमेंट स्कीम की ये खासियत है कि सपोज आपके खिलाफ कोई प्रोसीडिंग चल भी नहीं रही है, ठीक है, यदि आप लगे आपने कुछ गलत किया है जिंदगी में और सेबी को पता भी नहीं कि आपने गलत किया है, आप जाके बोल सकते हैं भैया मुझे लगता है कि शायद मैंने गलत किया है। ये मैं एक जनरल बात कर रहा हूँ, प्रकाश भी प्लीज करेक्ट मी इफ आई एम रॉन्ग। बोले मुझे लगता है कि मैंने शायद गलत किया होगा, इसलिए आई वांट टू सेटल द मैटर विदाउट एडमिटिंग और डिनाइंग गिल्ट। ये लीजिए लाख रुपया, 2 लाख रुपया, 5 लाख रुपया, करोड़ रुपया, 5 करोड़ रुपया, जो श्रद्धा है या जो सिस्टम में बैठता है, और चैप्टर क्लोज कर सकते हैं। वो ऐसा भी संभव है कानून के दायरे में, है ना प्रकाश भाई?
Yes, yes, correct.
तो प्रोसीडिंग्स का होना जरूरी नहीं है सेटलमेंट के लिए, सेबी के
particular for disclosure requirements.
So Prakash ji, the thing is that many of the recipients of such letters, they are seeing this subject matter for the first time. So should they rather take a plea? I mean, that is I know it's a difficult and a Hobson's choice. Should they take a plea कि कोई proceedings pending ही नहीं है, तो फिर मेरे against में मैं कैसे अभी इसको avail करूं?
नहीं, ये लेटर ये बता रहा है आपको कि आप ये सेटलमेंट अमाउंट नहीं भरेंगे तो आपके अगेंस्ट में प्रोसीडिंग्स इनिशिएट करेंगे।
15I में
इंटीमेशन दे रहे हैं, एडवांस इंटीमेशन दे रहे हैं, और खास करके ये जो सब्जेक्ट मैटर में स्कीम इसके लिए बनाई ताकि उनको में जो 14,000 एंटिटीज के अगेंस्ट में ये सब कोसी जुडिशियल प्रोसीडिंग्स इनिशिएट करके उनका भी समय बर्बाद होएगा, हर एक इंडिविजुअल का समय बर्बाद होएगा। टू रिजोल्व दैट मैटर दे हैव फ्रेम्ड ए स्कीम।
Correct, sir. Correct.
In comparison to the regular settlement amount, ये जो settlement regulation 2018 है, which has come in force from 1st January 2019, वो हिसाब से वो penalty calculate करेगा तो it can be much higher than what they are now asking from you.
Correct, sir. Understood.
That is why it is a scheme, settlement scheme 2020, only for this purpose.
एक और सवाल सर, I mean any chances or any likelihood of the last date getting extended?
See, we have come to know that some representations are likely to be made before the board. So one cannot rule out. However, one should not depend on that extension always. Finally, the facts are before you. Today you are in a position to decide. You have taken already 2.5 months around, say, to think over the subject matter. So once for all, you should decide and not wait for the extension. I don't rule out the possibility, but I do not suggest that decision making should be delayed and I mean one should wait for extension. There is nothing more required except payment of money and few filling up the forms. Nothing is required. It is not like filing of an income tax return that you have to collect data.
Sir, ये मैं इसलिए पूछ रहा था because a couple of writ petitions have been filed, one in Kolkata High Court and one in Rajasthan High Court. So अगर ये writ का decision नहीं आता है, कोई interim injunction वगैरह की उम्मीद में बैठे हैं, तो और by chance ये last date भी नजदीक आ रहा है, so in view of the writ petitions, whether one should wait and if one should wait till what date? 25 अक्टूबर तक देखे, 27 अक्टूबर तक देखे? What do you suggest, sir? That would be my last question, sir.
The one point is, I understand that High Court has a wider jurisdiction, writ jurisdiction and etc. So, I mean, first of all, it is I just don't say that you should pursue or I'm not promoting that, but once you have filed a writ, you should ensure that it is being heard on a priority basis since the scheme is coming to an end. So urgent hearing can be sought. I'm just suggesting as an advocate. I am not saying that you should go ahead with the writ, but the point is based on the facts as unknown, an urgent hearing can be sought.
This writ already filed किसी और ने की है. That's what I am trying to say.
I am just giving a legal opinion saying that in case, see, courts are hearing urgent matters, correct? So one has to make out a case if desired.
Okay, sir. Thanks a lot, sir. Thank you.
Thank you.
Mr. Sanjay Shah, please. Mr. Sanjay Shah? No? Mr. Alok Khetan?
Yeah, thanks for giving me this opportunity. I finally decided to pay up this penalty amount or whatever the scheme is. I was just going through the forms, sir, and the filling of the forms, I'm afraid, is not that easy because they are asking for net worth certificates, all those details and all, and they are asking not for the ITR acknowledgements, they are asking for, I think, the whole of the ITR. Whether I am mistaken or correct, please correct me, sir.
Hello.
Yes, sir.
If you can just ask me a particular query that under which part of Form A you are finding it difficult to fill in the data, then if possible, I will guide you upfront right now only. If you can just informed to me right now.
Question number.
I have the form.
They are asking for audited networks and all that.
Question number बताइए ना sir.
No. That is only applicable. See, if you see those, it is, you have to only give 3 years income tax return. Okay, no net worth. Net worth is in case of intermediary. Please look into the subject matter.
Intermediary, sir.
It is not required. Net worth of an individual who is not a, broker or intermediary is not required.
Intermediary also, sir, and I'm a member of the National Stock Exchange, as well as I've received in my personal capacity. In both capacities, I've received the settlement thing.
Sir, intermediary हो तो फॉर्म भर लोगे यार, इतने compliance पे तो मजबूत हो ही.
फॉर्म में
उसमें वो लास्ट 60-70 पन्ने का पूरा ITR होता है.
That means notice is a broker when you are saying so.
ये दो नोटिस है, एक इंडिविजुअल कैपेसिटी में भी है, ब्रोकर कैपेसिटी में है, दो अलग बात कर रहे हैं आलोक जी.
Network is not required. In my view, we have not filed the net worth of any other notices even in the regular course when we have filed the settlement.
ठीक है आलोक जी, I think प्रकाश जी will get back on that. और कोई point?
नहीं, मेरा ये पूछना था उत्तम जी कि जो पूरा इनकम टैक्स रिटर्न भरते हैं अपने, जो 60-70 पन्ने का है, वो पूरा देना है, डाउनलोड करके.
नहीं, इसमें लिखा है साहब, आप ये बना पता होगा. See in the FAQ under para, just Smith Bhai will assist you in that, because finally the procedural matter is looked into by Smith. Please answer.
In the FAQs which SEBI has given in scheme issued by Securities and Exchange Board of India on 27 July 2020, in that page number 3, point number D, in that it is clearly mentioned filing a physical copy of settlement application to be received by SEBI on or before November 5, 2020, along with the following documents. So there are list of 6 documents, in which one is settlement application in specified format as per annexure 1.
Part 2.
सर वो फॉर्मेट की बात कर रहा था मैं.
नहीं, ऑनलाइन में तो 2 ही चीज देना है, अंडरटेकिंग
3 चीजें देना है ऑनलाइन में. लास्ट 3 years सेल्फ अटेस्टेड इनकम टैक्स रिटर्न, सेल्फ अटेस्टेड पैन कार्ड, एंड वन इज अंडरटेकिंग.
इनकम टैक्स रिटर्न तो है, वो तो 70 पन्ने का होता है, तो पूरा 70
फर्स्ट पेज
एक्नॉलेजमेंट सबमिट करना है.
वो तो ITR एक्नॉलेजमेंट होता है सर, वो पूरा वो रिटर्न तो अलग चीज हो गई और ITR अलग.
उनसे ये सेटलमेंट में जा रहे हो, they will be lenient, they will only, so the first page will suffice, that is acknowledgement, that is not the details.
सर उनसे सेबी को एक बार ईमेल कर दीजिए ना.
अच्छा सर, दूसरा छोटा सा पॉइंट था सर मेरा, कि आज जो वेवर वाला जो फॉर्मेट है, उसका अगर सिर्फ पॉइंट नंबर 10 है, अगर एक बार देख ले सर, तो मेरे को थोड़ी सी क्लैरिटी आ जाएगी. उसमें ये लोग जो बोल रहे हैं, दे आर सेइंग दैट नाइदर एडमिट नॉट डिनाई. उत्तम जी, यू आर नॉटिंग योर हेड.
हाँ, तो ये स्टैंडर्ड लाइन है यार.
दैट इज ऑलराइट. आई डेफिनेटली इट इज अ स्टैंडर्ड लाइन, बट when we have a legal expert with us, we can always take an advantage, no? So that is why I'm just trying to take that advantage.
मुझे जो पता है मैं उन्हीं से सीखा हूँ. प्रकाश भाई आप बताओ.
I just say that we do not accept also. So that is, settlement schemes are always in that measure. So there is, even if you see the settlement order in comparison to the adjudication order, correct, you will find that no charge is upheld in the settlement orders. It is saying that the SOCOS was issued, it was settled, etc., etc. The only facts about the proceedings are mentioned, not the outcome. Whereas in case of adjudication order, it deals with each and every factors which are part of the SOCOS notice, and then either upholds or discharges you. So that is the difference. If you can see the two, different proceedings, like adjudication order and the settlement order is available in public domain. Large number of orders are available on the settlement.
My intention was that whether SEBI can use these 3-4 words, neither admit nor deny. So neither admit nor deny word, the last 2 words against us or against me in future in any manner, sir. Nor deny.
That is true. See, this is the format normally, as we have seen and accepted, that like banks where we have seen that the form which is there is a stereotype. Board resolutions are stereotype. So I think so far nobody has faced the proceedings saying that you settle the matter, so you have admitted the guilt. No other authorities have taken cognizance of an adversity of a settlement of proceedings.
Sir, if I am uncomfortable with this word, can I remove this word and file the waiver format, sir?
See, the point is, it is a format. We have only, it is not, in my view, it is not permissible.
Sir, thank you, sir. Thank you for your time, sir. Thank you very much, sir. Thank you, Uttam ji.
ये अलग है। संजय जी, संजय जी आपकी आवाज नहीं आ रही। कुशाग्र जी, no? Somebody from Redmi phone?
Uttam ji, can you hear me?
हाँ संजय भाई आपकी आवाज आ गई, बोलिए। हाँ।
Thank you. Uttam ji, part of my question has been answered. शो कॉज नोटिस तो आया ही नहीं है, तो सेटलमेंट स्कीम आया तो डायरेक्ट वो कर सकते हैं हम लोग। ओके। सेकेंडली प्रकाश जी, आई जस्ट वांटेड टू नो, नॉर्मल कंसेंट जो टर्म रहता है उससे ये स्कीम थोड़ा अलग है, क्योंकि उसमें भी इंडिकेटिव अमाउंट होता है और नॉर्मल कंसेंट में बाद में सेबी पे रहता है, वो उधर बढ़ा सकते हैं घटा सकते हैं। तो इसमें जो अमाउंट बोला गया है दैट इज फाइनल, आई थिंक।
Naturally,
okay,
because it is coming out from the same.
It's not like the normal consent terms.
See, normal consent terms, as you have seen, that there is always a internal committee meeting which is held. Then you file the, if desired, you may file the revised consent terms, RCT, correct? Yeah. And then it is processed. So there also, it is only at the time of internal committee meetings, the regulator discloses the amount that can be proposed to be settled, which then will be considered by the high power action committee and then by the learned whole time member. Here the whole process has passed through it. The scheme, as we understand, has been approved by the SEBI board and got the approval from the hierarchies wherever it is required, because it is part of the regulations. So one has to believe, and not only believe, go ahead with the fact that if you pay this amount, the matter is settled. There will be no either reduction or enhancement. I'm thinking saying so.
Okay.
Because it is approved by the board.
Thank you. Thank you.
Redmi phone. I want to ask one question.
Yes, sir.
Should I go? Yeah, my question is regarding limitation of time में जो बताया जा रहा है कि 7 years is too late to start a proceeding. उसी एक तो स्टैट का ऑर्डर भी है that 17 months after the investigation was over to issue a SCN was quashed. Now the investigation is over for us in the year 2017. Already 3 years have passed. Will that be helpful to us?
Whatever is helpful to the persons who are continuing with the proceedings voluntarily, I have relied upon the orders and indicated. Correct. It is finally for the other side, that is the judicial authorities, to take a call. I mean, justify.
No, like 17 months was too late to to issue the SCN. Now in our matter, SCN has not been issued. 2017 was the investigation over.
प्रकाश भाई, would it be a fair thing to say कि भैया हाँ डिले है, उसका अपना डिफेंस जिसको लेना है वो ले लो, पर डिफेंस चलेगा कि नहीं चलेगा डिपेंड्स ऑन हाउ द जुडिशियल अथॉरिटी फॉर्म्स अ व्यू.
I think you have made it a simpler way. You have conveyed what I wanted to say. Yes, thank you. Yes, correct. Uttam ji, your answer is absolutely correct.
Thank you ji.
And one more thing. ये जो सेबी बता रही है कि ये सिंक्रोनाइज ट्रेड्स है, इन बिटवीन टू पार्टीज फोन करके 1 2 3 करके पंचिंग किया, बट लिटरली इन दिस प्रेजेंट वर्ल्ड इट इज नॉट पॉसिबल. इवन इफ यू try to synchronize trades, 10 trades, out of that 10 trades, if you ask SEBI to prove it by synchronizing it, it will not be possible if it is at unfair price. वो punch होएगा ही नहीं, because there is algo software. Then why can't we at senior level lawyers just challenge the SEBI to fight that you prove it that it can be synchronized? Out of 100 trades, match 50 trades also. It is not next to impossible. It is next to impossible to match that sequence because it is not a blocked window that.
सर बहुत आर्ग्यूमेंट्स हुए, सैट में लंबा चौड़ा चला, और सैट का ऑर्डर पढ़िए, काफी अभी तो मैटर सुप्रीम कोर्ट में जाएगा, हाई कोर्ट में जाएगा, रिट में जाएगा, ये सारे पॉइंट्स उठेंगे, बट आज की तारीख में ये पॉइंट कहीं चला नहीं है।
हाँ मतलब चला नहीं, मतलब यही एक तो फैक्ट है।
आर्ग्यू तो सर आप समझिए, जो भी सेटल नहीं करेगा और जो एजुकेशन में जाएगा, 400 आदमी के खिलाफ ऑर्डर आए हैं, तो 400 आदमी ने अब तक लीगल काउंसिल आगे अपने अकल लगा के सब कुछ किया होगा ना, जिनको एक्चुअल शो कॉज आया, एंड अभी तक तो रिजल्ट ये है। फिर बाकी तो एकेडमिकली डिस्कशन अपने कर सकते हैं, बट लेट्स स्टिक टू पर्टिकुलर लीगल पॉइंट्स। शायद ही हो सकता है, बिल्कुल सही है, मतलब हर तरह के आर्ग्यूमेंट्स लिए जाएंगे, किसी ऐसा नहीं कि 14,000 लोग सेटल करने वाले हैं, ठीक है। जिनको कुछ लोग आती लगेगा वो नहीं करेंगे, और जो बोलेंगे भैया मेरी गलती नहीं है, फिर भी कई लोग जान छुड़ाने के लिए सेटल कर लेंगे कि भैया आई डोंट हैव द टाइम एनर्जी एंड आई डोंट, मुझे मैं इट्स लाइक मेरे सर पे किसी बंदूक रख दे तो पैसे ले जा, मुझे तंग नहीं करना। कुछ लोग बोलते हैं तो मुझे गोली मार दे, तो गलत आदमी, मैं तुझे नहीं देता। हर आदमी का अपना एटीट्यूड होता है, अपना स्टाइल होता है, उस हिसाब से डीलिंग होगी।
लेकिन प्रैक्टिकली ये पॉसिबल ही नहीं है कि आज के डेट में
वो पक्का सर आर्गुमेंट स्टेज पे लिया जाएगा, बट सर लेकिन ना सैट यहाँ है ना सेबी। एनीवे, और कोई सवाल सर?
थैंक यू
सर। कुशाग्र जी, यादव जी, अच्छा कुशाग्र जी ऑन, यस ओके। हाँ
मेरा क्वेश्चन ये है और मेरा सवाल ये है, क्या बात है, सपोज वो इन्वेस्टर अगर ना एडजुडिकेशन में जाता है, ना सेटलमेंट देता है, कुछ नहीं करता है, तो किसी का 1 लाख रुपए अगर उसका प्रॉफिट आया एक सिंपल ट्रेड में, तो उसमें सेबी उसके अगेंस्ट में क्या एक्शन ले सकती है एट द मोस्ट?
मैं आपका क्वेश्चन रिपीट कर रहा हूँ। सपोज आपने सेटलमेंट स्कीम का पार्ट नहीं लिया, मिस्टर एक्स ने, और फिर सेबी में एडजुडिकेशन हुआ, उसमें भी आप उसको गए नहीं, जो करना है कर लो, सेबी ने ऑर्डर पास कर ले कि भैया तुमसे 100 रुपया लेना है पेनल्टी, सपोज 100 रुपया हो, 5 लाख हो, 10 लाख हो, जो भी है, कोई फिगर आ गया, सेबी आपका क्या बिगाड़ लेगी? बेसिक यही सवाल है मोटा मोटी। आपके बैंक अकाउंट, डीमैट अकाउंट सब फ्रीज हो जाएंगे, है ना प्रकाश जी?
Correct. Later on, after 40, when the adjudicating officer order is passed and served upon the noticee, thereafter, from 45 days onwards, SEBI has a right to initiate recovery proceedings against the noticee, and in response thereto, if the amount is not paid, in fact, interest at the rate of 12% start accruing from the 45th day of the receipt of the order by the noticee. So it is a continuous liability on the person to pay off. In the past, when the recovery powers were not available with SEBI, they have initiated prosecution, and large number of persons have settled the matter under compounding before the sessions court by paying 12% interest plus legal cost of say 67,000 rupees, and then got rid of the proceedings, criminal proceedings against initiated against them. The person, a very well-known person who did not pay 6 lakhs rupees, had to undergo imprisonment for 3 months for just breaking the that order, that is bail application, violating the bail orders of traveling outside India. So this is the consequences.
Okay, thank you.
So apart from civil, SEBI can also, if penalty is not paid, SEBI can file criminal prosecution against you.
Okay, sir. Okay.
Is it right, Prakash ji?
Yes, correct. That is, okay. I'm giving an example. Jumping off bail. What is proper? What is, because of jumping off bail? Once the criminal proceedings are initiated, one has to surrender the passport or get permission to travel abroad. Just I'm saying so.
Okay, okay. Thank you.
He was ready to pay 10 times.
But jail अभी, बाप रे। यादव जी,
बस यही लास्ट सवाल था जिसका जवाब अभी आपने दिया है सर।
बहुत भयंकर जवाब था, ये तो मुझे भी नहीं पता था। Anyway, प्रवीण जी।
Hi, good evening. Am I audible?
Yes, Praveen ji. Please.
Yeah, hi. Thank you, Prakash, for spending so much time and enlightening us, and thanks BBF for giving this opportunity. So, मेरे सर कुछ छोटे-छोटे सवाल है. First is there any possibility that if we apply for settlement and then SEBI receives all the documents and forms and everything, and then SEBI denies the settlement. Are there any circumstances where this is possible?
If any false information is furnished, then only under that scenario they may refuse. Otherwise, we have not seen otherwise the reasons.
Okay. Okay. Then, sir, my next three questions are moreover from the operational aspect of the settlement. So we touched on the form of the settlement, and can you please guide me on the point 17 and point 20 of this form, wherein it asks us for the details, like the numerical details.
The details with regard to just a minute, please. FAQ. Which
he's asking to 17.
Yes, sir. 17. 17. So full and true disclosure of facts.
True disclosure of facts, including the loss cost. So you have to enclose this printout, which is coming out from the portal.
Okay. So the summary thing which is coming out. Right?
So that includes the number of trades, number of contract, etc. in the volume.
Okay. And so point number 20 as well.
Terms of settlement.
As mentioned in that amount.
As mentioned in that amount. Fair enough. Okay. So what will be the value of stamp paper for the undertaking?
200 rupees.
Okay. And sir, can you please also guide me to point number 12E and 12F of the undertaking, as in what does it indicate? I mean, to a layman like me, it's very difficult to understand what the point says. 12E and 12F of the undertaking.
12A.
12E.
E for elephant and F for penguin.
Any plea relating to such provisions of the other requirements of law, including conflict of interests, may be construed to prevent any member or officer of the secretary from participating in the proceedings, including settlement. It is not applicable to you. Okay. I don't think it is applicable to any other person. There is no conflict of interest, correct?
Okay.
And it is okay. Inconsequential, in my words. Don't think too much on otherwise having an impact or a declaration. Correct?
Okay. Okay. And so 12F as well, sir, if it is applicable.
Any plea of bias or prejudgment by the SEBI, the officer. See, there were in past certain complaints against the regulator saying that they were forced or they were, put to hardships by saying so if you don't settle, etc. So these are the format which has been prescribed. So no inconsequential to you in your case.
Okay.
Correct?
Okay, sir. Thank you. Thanks a lot.
Welcome.
Uttam ji, you're on mute.
Thank you, Praveen ji, for very specific questions. Really appreciated that. Bhavesh ji, you raised your hand.
Sir, from where can I get this FAQs and all?
SEBI portal, we will provide in case of it. We provide an email to Uttam ji.
Okay.
FAQ is on the SEBI portal.
Okay. Thanks.
Chirayu ji.
सर जस्ट अ वेरी स्मॉल क्वेश्चन. आपने कहा था कि जब लास्ट मेरा आपसे डिस्कशन हो रहा था ये आपने कहा था कि आप नंबर ऑफ वॉल्यूम्स जो अपनी ट्रेड वॉल्यूम है वो आप पता कर लीजिए व्हाट इज द टोटल ट्रेड वॉल्यूम यू हैव डेल्ट इन एंड इट हैज हैपेंड ऑन दैट पर्टिकुलर डे और पर्टिकुलर डेट. सर वो कैसे पता चल सकती है, कहां से पता चल सकती है?
वो स्टैटिस्टिकल डेटा बीएसई की वेबसाइट पे मिल जाती है अबाउट द टोटल वॉल्यूम एंड इवन इन द सो कॉज नोटिस सेबी प्रोवाइड्स इट. Fairly, I can show you the order.
आप शोकॉज तक पहुंचे नहीं है चले जी, वो आपको शोकॉज तक पहुंचे नहीं है, लेकिन बाकी ऑर्डर्स के अंदर मिल जाएंगे क्या?
शोकॉज आई नहीं ना हमको ऐसे बोला.
नहीं, it is they say is providing. Right now it is not available.
Right now it is not available. We are talking about right now.
Right now. They say BSC website.
Only BSC website you can rely upon.
Sorry sir, I couldn't get you.
You want me to answer that question, that from where you can get the market volume of the contract, is it correct?
जी sir.
BSE maintains the historical data of volume executed on their platform.
Okay. तो उसमें
bsindia.com में टर्नओवर में देखेंगे ना, कहीं मिल जाएगा सर. हर कॉन्ट्रैक्ट का डिटेल होगा, हिस्टोरिकल
सर,
डेटा
ये
सब होगा।
स्क्रिप्ट नेम जो होता है, दिस इज दी, और ये कैसे पता चलेगा?
कॉन्ट्रैक्ट होता है वो, स्क्रिप्ट नहीं।
ओके, आई थिंक वील हैव टू स्पीक टू द ब्रोकर, आई थिंक, जिससे हुआ
हाँ,
होगा
आपका
ये,
स्टॉक
राइट?
ब्रोकर आपको गाइड कर पाएगा सर। हाँ,
राइट। थैंक यू उत्तम भाई। उत्तम भाई, जस्ट वन स्मॉल थिंग,
बोलिए ना आप कुछ। हाँ,
कैन आई हैव योर ईमेल आईडी? सॉरी, मैं बहुत डिस्टर्ब कर रहा हूँ आपको।
नहीं सर, तो सब ब्रोकर्स फॉरम contact@brokersfirmofIndia.com पे करिए, कोई भी तरह का मदद कर सके तो। बट ब्रोकर्स फॉरम में यूजुअली the request has to come through the broker and the client should not come directly, ideally.
Okay.
वरना हम पागल हो जाएंगे सर।
I know, I can understand that. इसीलिए मैं बोल रहा था कि आपको परेशान कर रहा हूँ। Right.
हाँ, okay.
Thank you.
चेतन भाई। हाँ चेतन भाई, any questions here?
पर्सन एक्सपायर हो गया तो लायबिलिटी रहती है?
यदि कोई एक्सपायर हो गया तो कोई लायबिलिटी रहती है क्या?
2017 में
आंसर इज नो, नहीं कोई लायबिलिटी नहीं है।
मेरे को रिस्पोंड करना है।
वाइंडिंग अप, कंपनी वाउंड अप,
नहीं, यदि कंपनी वाइंड अप हो गई तो जैसे एक ऑर्डर का एग्जांपल दिया था प्रकाश भाई ने, तो वो चैप्टर क्लोज हो गया। वैसे किसी इंडिविजुअल की डेथ हो जाए तो क्या उसकी एस्टेट पे लायबिलिटी आती है कि नहीं, इज द क्वेश्चन, है ना चेतन भाई?
इट इज ओनली आफ्टर द ऑर्डर इज पास्ड, नॉट प्रायर टू दैट। पेंडिंग प्रोसीडिंग्स आर ड्रॉप।
हाँ, सो
इसमें आएगी लायबिलिटी?
नहीं आएगी साहब। यदि
रिस्पोंड करना है
तो आप सेबी को कम से कम लेटर लिख दो कि इनकी ये रहे नहीं, और डेथ सर्टिफिकेट कॉपी लगा दो, तो मेरे ख्याल से
नोटराइज कॉपी लगा दो, नोटराइज कॉपी ऑफ द डेथ सर्टिफिकेट,
नोटराइज कॉपी ऑफ डेथ सर्टिफिकेट जो लगा दीजिए। बट प्रकाश भाई ने एक बोला कि यदि ऑर्डर पास होने के बाद किसी की डेथ होती है तो फिर बच नहीं सकते एस्टेट पे लायबिलिटी, लेकिन ऑर्डर पास होने से पहले कोई रहे नहीं यदि, तो फिर उनपे सेबी प्रोसीडिंग्स डिसकंटिन्यू कर देती है। मैंने काफी ऑर्डर्स पढ़े हैं, ऐसे ही होते हैं। ठीक है चेतन भाई? ओके, नवरत्न जी, प्रतीक प्लीज। हाँ नवरत्न जी।
हाँ सर, आ रही है आवाज?
हाँ, आ रही है।
हाँ, नमस्कार सर।
अच्छा
सर, मेरा सवाल ये था कि अगर मैं सेटलमेंट की स्कीम चूज करता हूँ तो इनकम टैक्स की, ईडी की, ये सब लायबिलिटी अराइज होगी या नहीं होगी?
तो इसके बारे में प्रकाश भाई ने अभी 20 मिनट पहले किया था।
अच्छा, उस टाइम में
वो तो पॉइंट्स किया, वो आपके प्रकाश भाई ये सिक्योरिटीज लॉ के एक्सपर्ट है, इनकम टैक्स लॉ के एक्सपर्ट नहीं है। ये दूसरी बात है कि सब कुछ के बारे में प्रायर नॉलेज तो होता है। इसका जवाब मेरे ख्याल से आपका सीए परफेक्ट दे पाएगा। बट प्रकाश भाई ने काफी चीजें कही थी। नंबर 1, क्या ट्रेड नकली थोड़ी है, ट्रेड तो असली है, उसका पेन पे आउट हुआ है। इट इज अ जेन्युइन, इट्स नॉट दैट इट्स अ नॉन जेन्युइन ट्रेड। सेक्रेटरी ने काफी रेफर किया था, तो प्लीज गो थ्रू द वीडियो अगेन ऑन यूट्यूब ऑन दैट पार्ट, एंड उससे आप जो क्लू ले सकें सर। मैं थोड़ा जस्ट टू फॉर एफिशिएंसी में आई एम ट्राइंग टू अवॉइड रिपीटेशन, अदरवाइज रात भर तक यहीं रह जाएंगे। थैंक यू। रेडमी फोन हैज अ क्वेरी अगेन।
अगर कर्ता की डेथ हो जाती है तो क्या को-पार्टनर के ऊपर में लायबिलिटी आएगी क्या?
अरे बाप रे, हाँ।
एससीओ नीड्स टू बी डिसॉल्व्ड।
हाँ,
डिसॉल्व करने से नहीं
वो आपको उत्तम जी ने पहले भी बता दिया कि you consult your own I mean persons like chartered accountant and etc. to guide it properly. The entity, if there is non-existent entity, proceedings does not continue. Non-existence entities.
अच्छा, और सुप्रीम कोर्ट से कहीं से भी ऑर्डर ऐसा भी आ सकता है कि 5 लाख की जो मिनिमम पेनल्टी है उसको कम कर सकता है कोई सैट, या वो छोटे ट्रेड वाले लोग के 1 लाख वाले?
The law is framed by parliament, not by Supreme Court. They are the implement executors. Correct? It is provided under the SEBI Act.
हाँ, अब उसमें क्या है, जब रेड पिटीशन फाइल हुए, हाई कोर्ट ने कुछ फेवरेबल दे दिया या कुछ बोल दिया कि नहीं छोटों को छोड़ दो, पता है कुछ भी हो सकता है, बट चांसेस कम है। मतलब सी पॉइंट इज कोर्ट्स का काम है जस्टिस करना। यदि कोर्ट्स के मामले सामने मैटर गया और कोर्ट्स को लगा कि इनजस्टिस हो रहा है तो जस्टिस कर सकते हैं, बट सवाल ये है कि इनजस्टिस हो रहा है कि नहीं, इसके ऊपर डिबेट चलेगी, और डिबेट का क्या आंसर आएगा किसी को नहीं पता।
ओके, थैंक यू।
है ना प्रकाश भाई? फेयर थिंग,
absolutely right. But it is framed under the SEBI Act that minimum penalty of 5 lakh is stipulated under the SEBI Act under Section 15H passed by the Parliament.
Right. Okay, I'm so happy we have run out of questions, which with some time to spare. Uh, Prakash bhai, and again we start on time and we try to end as soon as the question is done. So on, Prakash bhai, any closing comments you want to make before I give a formal vote of thanks?
See, the point is, ideally, I have summarized the factual aspect of the subject matter in a broader way. It is, as you rightly conveyed, that it is on the mindset of a person whether to go for a settlement or continue with adjudication proceedings. So that is a broader advice saying that, but finally, my suggestion is that instead of waiting till the last date, one should take a firm decision at the earliest so that a proper conduct is shown to the regulator and proceedings can come to an end in a better manner. So instead of waiting for a longer, my last suggestion and message is let the entity person decides at the earliest so that better things can prevail.
Right. So, on behalf of Bombay Stock Exchange Brokers Forum, on behalf of the intermediary community that I represent, on behalf of all the clients that the intermediary community represents, thank you, Prakash Bhai, for throwing light. I strongly believe, and BBF also strongly believes, that education and training is the most important aspect of the association. क्या what to do, what not to do is opinion, but कई चीज होती है facts and understanding. ठीक है, जो यदि कोई अथॉरिटी प्रोवाइड कर दे तो सबके लिए डिसीजन मेकिंग आसान हो जाता है. And we are just trying to solve ignorance issues, and it's really helpful when someone who is really involved in these activities is able to share his thoughts and his understanding. आपकी जो समझ है, जो आपने 1 घंटे में या 1.5 घंटे में जो ज्ञान दिया है, उसको एकत्रित करने में डिकेड्स लगते हैं. So thank you for being so nice and sharing it with us. आसान नहीं है. जैसे शेयर बाजार में हम खां हैं, खुद को खां मानते हैं, वैसे लीगल में आप खाओ. और ये खां तो आदमी तभी होता है जब बहुत बहुत आपको आहुति देनी पड़ती है समय की, बहुत मेहनत करनी पड़ती है. It is not easy to become an expert or get knowledge in any subject. And thank you very much for being so free and sharing with us. It is really appreciated. On behalf of all of us, thank you so much, Prakash Bhai and team. Thank you so much.
Thank you. Namaste.